Yes, Mr. President.
The Leader of the Opposition.
Yes, certainly.
Paul. Thank you, Mr. President. I speak for the opposition. I lead for the opposition on the Children and Young Persons Care and Protection Amendment Bill 2018 and, of course, the National Disability Insurance Scheme (brackets Worker Checks) (brackets Bill 2018). As we've already canvassed in this House, the bills have been introduced as cognate bills, notwithstanding the fact that they are unrelated. Therefore, Mr. President, I make a request that the second reading votes be separated and voted on sequentially and they be dealt with in that way. The reason for that is, I can indicate, the opposition opposes the first bill. We will have amendments should we not succeed in opposing the bill on the second reading. However, we do not oppose the NDIS legislation. The NDIS is a Labor project, albeit one that's not being handled very well by the current government, state and federal, and we do not oppose the measures in that bill. And so we wish to express those clear views in the way in which we vote in this House. The Children and Young Persons Care and Protection Amendment Bill 2018 seeks to amend the Children and Young Persons Care and Protection Act and the Adoption Act 2000. It's a matter of record that a discussion paper entitled Shaping a Better Child Protection System was issued in December 2017, outlining proposed legislative amendments to a select group of stakeholders and requesting submissions. Submissions, Mr. Assistant President, which have never been made publicly available. The community legal sector and other important stakeholders in this space formed what we consider to be a reasonable expectation that a draft exposure bill and further more detailed consultation would be released prior to the introduction of legislation to this Parliament. The government, of course, could also have produced an exposure draft and let it sit upon the table. Instead, the report on the consultative process was released on the same day as the bill was introduced into this place. Affected stakeholders, including Aboriginal and Torres Strait Islander communities and organisations, have simply not had sufficient time to consider or respond to the full implications arising from the proposed reforms. Consequently, Mr. Assistant President, I will move an amendment to the second reading vote that instead of that this House that this bill be read a second time, after this House, the words refer the bill to the Legislative Council Standing Committee on Social Issues for inquiry and report into the consequences of the legislation, particularly for children and families with complex and special needs, unquote. And I move that way. Because, frankly, this bill is being rushed. Its content is hastily put together and ill-conceived. And without wishing to be alarmist, the measures in the legislation, if made law, run the risk of creating an instrument by which we would create the potential for another stolen generation of children to be removed from their families. That is something that we should step back from. That is something that we should look that is a reason to look very closely at these provisions and to make sure that in the government's desire to improve the system and to provide additional protections for vulnerable children, we don't in fact do more harm. Now, what does this legislation do? The amendment bill changes guardianship orders to allow the Children's Court to make an order by consent to reallocate parental responsibility without the requirement of a care application or the finding that the child or young person is in need of care and protection. The Children's Court may also make a guardianship order by consent without the necessary finding that there is no realistic possibility of restoration if the child or young person to his or her parents. The amendments to the Adoption Act will also enable the Supreme Court to make an order without parental consent, permitting the adoption of a child by the child's current carers or guardians. The bill also limits the period for which the Children's Court may allocate all aspects of parental responsibility to the minister, and the period in which the feasibility of restoration of a child or young person to his or her parents may be considered to a period of just 24 months. The bill makes amendments that require the Children's Court to take into consideration the amount of time the child or young person has been with the present caregivers and the stability of present care arrangements when considering granting leave to vary or rescind the existing care order. The amendments also require the Department to offer alternative dispute resolution processes to the families of children and young persons at risk of significant harm before seeking care orders. The bill amends the current legislation to enable the Secretary of the Department to ask a government department or agency or a government-funded non-government organisation to provide prioritised services to a child assessed and their family, as well as extending the time frame that the court is able to make orders allowing a child subject to a guardianship arrangement to have contact with their parents or family to the duration of the guardianship order. The bill also allocates responsibility for a child whose guardian or carer has died to the Secretary for 21 days or until the court makes an order allocating parental responsibility for the child. While the Secretary has responsibility for the child, he or she must investigate and assess the most appropriate care arrangements for that child. The NDIS legislation, the Workers' Checks Bill, gives effect to New South Wales' obligations under the Intergovernmental Agreement on Nationally Consistent Worker Screening for the NDIS. Under this bill, all NDIS workers will be required to apply for a check consistent with the Working with Children and Vulnerable Persons check. It's designed to protect persons with disability from abuse, violence, neglect and exploitation. And as I indicated at the outset, the Labor opposition does not oppose that second bill or its contents. To return to the first bill, in relation to the care and protection system, we are concerned, vitally concerned, in relation to the 24-month time frame about which I spoke a little earlier. The introduction of an arbitrary time limit for families to work towards restoration is a great concern. The proposal restricts the court to considering whether the children can be restored to their families within a period of 2 years or less. This effectively limits the court's discretion to grant flexible care and protection orders on a case-by-case basis and to make orders crafted to meet the needs of individuals and their families. And that's really important. Families, particularly broken families, vulnerable children, they're not machines. You're not repairing a house or a car or a piece of equipment. You can't just patch it back together. It takes time. It takes investment. It takes care. And everybody moves or develops at a different pace. And I know there are members in this House, the Honourable Peter Primrose, the Honourable Mick Veitch, who know about caring for vulnerable kids and working in that sector. And it's very important that we actually have a system that is responsive to individual needs. Those opposite, the Liberal Party, trading under a false name, Mr. Assistant President, but nevertheless, they're always talking about the freedom of the individual, the fact that government needs to be responsive to individual needs, and yet we have this sledgehammer to crack a nut proposal. So we think that there should be there should remain an open-ended mechanism rather than one that is so limited in this case. The proposal fails to impose corresponding obligations, for example, on the department to provide intensive, holistic support to families to achieve restoration within that proposed timeframe. Many families face systemic barriers to achieving restoration within 2 years, including a chronic and well-documented lack of public housing. Public housing not fit for purpose. I note in parenthesis that the several $100 million maintenance backlog this government said they inherited from the previous government hasn't actually been filled in 8 years, despite $50 billion worth of privatisation. Obviously, looking after vulnerable families and individuals is not a priority for them. Building stadiums, yes, it's all going to that. There's also a lack of accessible support and rehabilitation services. Rather than setting families up to fail by imposing arbitrary time limits, the government should introduce a scheme of comprehensive legislative supports that prevents removals in the first place or provides support towards restoration tailored to individual family needs. In relation to guardianship and adoption orders, the proposal would allow the courts to make an order under Section 38 without a parent's consent, even where the department has made no finding that a child is at risk of significant harm or should be subject to a care and protection order. The requirement that parents considering consenting to guardianship orders have access to free legal advice does not actually go far enough to ensure appropriate accountability once such orders are made. Proposed changes to the Adoption Act that broaden the Supreme Court's power to dispense with a parental consent where an adoption order is sought by a child's current guardian should also be opposed. The two proposals create a fast-tracked pathway to adoption without an adequate regulatory framework to provide oversight and protection and to protect the best interest of vulnerable children. As I said, there are additional barriers to seeking variation of care and protection orders. The changes to Section 90 of the Act make it harder for parents to apply to vary or dismiss care and protection orders. According to the Department's report on the outcomes of its consultation on proposed reforms, there is little community support for changes to Section 90. The explanatory materials to the bill give no clear rationale for the proposal requiring the court to consider the stability of a child's current placement when granting leave to a parent to make an application to vary or to dispense current care and protection orders. In its current form, Section 90 already sets a very high bar for parents seeking to change care and protection orders. The section also enables the court to dismiss unmeritorious applications where an applicant cannot demonstrate an arguable case. Rather than further limiting parents' access to the courts, the government should ensure they have access to free and independent legal advice when seeking the court's leave to make an application under Section 90. There is inadequate provision for independent legal advice and representation in this bill. Requiring family and community services to engage families in alternative dispute resolution before seeking care and protection orders from the court to be effective requires accessible independent legal advice to address the power imbalance that exists between families, particularly vulnerable and dysfunctional families, and a government department. And this is necessary to support parents to fully participate in a process and to ensure that placing a child in out-of-home care is always considered as an intervention of last resort. So it's no good having a technical right or a technical avenue for a parent or set of parents to pursue if they lack the means to properly engage.
Fantastic. Thank you.
And they lack the support. Because we are dealing with broken and vulnerable people and families, and if the processes are to be meaningful and to give substantive and not mere legal rights or bare technically legal rights, we need to make sure that all persons can properly engage. This is not a criticism of FACS or its officers, whom we know work tirelessly and in the public interest and in the interests of vulnerable communities, families, individuals. But there's no use creating a new process if people can't use it. Families with specialist need, including people with cognitive disabilities and Aboriginal and Torres Strait Islander people, should also be guaranteed access to specialist non-legal support. Community legal centres are perfectly placed to support families participating in alternative dispute resolution with the department, and along with the Aboriginal Legal Service New South Wales /ACT and Legal Aid New South Wales, should be adequately funded to provide these services. So these are very, very important if we are going to meaningfully actually raise the bar here, which I assume is the government's intention. As I indicated, there's a significant group of stakeholders in this space who are shocked and alarmed at what the government here is doing. And today, a group involving ABSEC and Community Legal Centres New South Wales and the Jumbunna organisation located at the University of Technology have today, with many other groups, authored a joint letter to the Premier. And I might just take time to read some extracts from that letter. And I quote, "Dear Premier, we're writing to urge the New South Wales Government to act in the interest of children and communities in New South Wales by turning away from the path of forced adoptions and avoiding the mistakes of the past. Forced adoptions played a central role in the trauma that led to the national apologies to survivors of institutionalised child sexual abuse, the forgotten Australians and the stolen generations. There was also a specific national apology to victims of forced adoptions in 2013 and a government apology in 2012. It is our collective responsibility to learn from these mistakes and to ensure that children are safe and families have the supports they need to be part of creating strong, safe and healthy communities. The New South Wales Government is on track to repeat these mistakes, with potentially devastating consequences for children and their communities. The Care and Protection Amendment Bill 2018 is currently being rushed through New South Wales Parliament without genuine input and engagement with Aboriginal communities and other organisations that work with the children and families who will be impacted by these reforms. Decades of research and multiple royal commissions and inquiries have provided strong recommendations about meeting the needs of children and young people, reducing the number of children in out-of-home care, requires community development and the provision of early support services that families need when they are going through hard times. The New South Wales Government is ignoring this advice and returning to the failed policy of forced adoptions. The New South Wales Government is on a dangerous path to ruining lives and tearing families apart. The legacy of these reforms will be another government apology for traumatising another generation of children. We urge the New South Wales Government to put these reforms on hold and engage in genuine dialogue with all stakeholders, including Aboriginal communities and community organisations supporting children and families in this area. We look forward to your response." And I end the quote there. Now, there are 61 organisations that have put their name. Community Legal Centres New South Wales, ABSEC and Jumbunna, Domestic Violence New South Wales, Grandmothers Against Removals, the Elizabeth Evatt Community Legal Centre in my region of the Blue Mountains, Just Reinvest New South Wales, Western Sydney Community Legal Centres. 61 separate organisations whose names I could read onto the record one by one, but I won't. There are also a range of individuals who are themselves active in this space or have themselves had first-hand knowledge of the defects in the system, but know also the further damage the provisions in this bill would do. There is 700 names that have supported this letter, along with the 61 specialist organisations, asking that the New South Wales Government just pause to reflect on what this really means. The Law Society of New South Wales, the peak organisation of solicitors in this state, has also written to the relevant minister, the Honourable Pru Goward MP, and they have made a number of recommendations. Their first recommendation, Mr Assistant President, is that the bill should be referred to an inquiry, which is why I've moved the amendment to the second reading motion before the House. They also oppose the maximum 2-year time limit for restoration and indicate that clauses 20, 25 and 27 to Schedule 1 of the bill should be removed or amended at least to exclude Indigenous children. The Law Society also opposes guardianship orders by consent and dispensing with parental consent where adoption is sought by the child's current guardian. Clauses 13 and 14 of Schedule 1 and all of the clauses in Schedule 2, they think, should be removed or amended again to exclude Indigenous children and to state that each party other than the Secretary of the Department should be provided with independent legal advice and, in the case of Indigenous parties, advice that is culturally competent. Let's just pause there for a moment. When this House, with goodwill everywhere, debated the Aboriginal languages legislation, not that long ago, we reflected on the need for cultural sensitivity, for understanding and awareness. And the goodwill experienced in this chamber on that occasion is entirely missing from this debate, or at least from the awareness of the government on this bill. Because, as we well understand, Mr Assistant President, as you well understand from your long years in public life and in this place, with your strong association with Indigenous matters, you know the particular disadvantages that Aboriginal and Torres Strait Islander families and communities have laboured under since European settlement and as a result of the dispossession that they have experienced. And I would urge all honourable members in this chamber to listen to the pleas from the 700 individuals, the 61 organisations and from Aboriginal and Torres Strait Islander communities to not inflict this legislation on them, at least not without a full inquiry into what the consequences of these provisions would be. The Law Society also opposes the additional limitations on applications to vary or dispense with care and protection orders. Their view is that the Section 90 of the Children and Young Persons Care and Protection Act should remain unchanged. The factors set out in subclauses 29 brackets 2A and 2B should be given equal weight. The reference to the stability of present care arrangements in subclauses 29 2B little b and 32C should be removed in their view. The Law Society also supports the requirement for ADR processes, but indicates that they must be supported by the provision of independent legal assistance. Clause 12, Schedule 1 should be amended to require the provision of independent legal assistance to the family of a child or young person at risk of significant harm. In the case of Indigenous parties, the legal advice provided must again be culturally competent. The Law Society is also deeply concerned about the lack of opportunity for public scrutiny of this legislation, and that's why their first recommendation is that it should be referred to a parliamentary committee for inquiry to allow for adequate public engagement and scrutiny of what are, on any view, very significant reforms to the care and protection system. There are a range of other concerns set out by the Law Society in their letter to the relevant minister. And I've given a summary of those, but the substance is the same, that the government should not rush. There is a further joint statement that was issued earlier in this process from a whole range of organisations, including Save the Children, again, community legal centres, the Aboriginal Legal Service and others. Again, I won't read it out in full, Mr Assistant President, but I will at least provide this House with a flavour, and I'm happy to table these documents if that would assist anybody. And in fact, I seek the indulgence of the House to be able to do so. Quote, the recent announcement by the New South Wales Government that significant legislative reforms to the statutory care and protection system will be introduced to Parliament has stunned stakeholders, including Aboriginal community bodies and community legal advocates, citing the lack of transparency and public dialogue on this important area of public policy. The group, including ABSEC, New South Wales Child, Family and Community Peak Aboriginal Corporation, the Aboriginal Legal Service, New South Wales /ACT, Community Legal Centres New South Wales, Public Interest Advocacy Centre, Kinchela Boys Home Aboriginal Corporation, Burundali Aboriginal Corporation, the Benevolent Society, Professor Terry Liebsman, brackets UTS Law, KARI, that is capital K-A-R-I, Save the Children Australia and Amazon Aboriginal Health Service have repeatedly called for greater transparency and consultation with respect to reforms that go to the heart and soul of our society, our treatment of the most vulnerable members of our community. Following a brief consultation process in response to a Family and Community Services discussion paper, Shaping a Better Child Protection System, in October 2017, there has been a disturbing silence about the scope and substance of the proposed changes, with the public and sector stakeholders apparently having to wait for the draft bill to be tabled in Parliament to see what the government has decided to do. It goes on, Mr Assistant President. The lack of openness is deeply troubling for Aboriginal communities in particular, given the significant and disproportionate impact that the statutory child protection system continues to have on the lives and well-being of Aboriginal children and young people, their families and communities. It concludes, we call on the New South Wales Government to reconsider the progress of these amendments and urge all members of the Legislative Council to send this bill to committee, allowing a meaningful public engagement and consultation process so that the public, including children and young people and Aboriginal communities, can genuinely inform the proposed changes, understand their implications, and take part in an open and transparent dialogue about the scope and detail of legislative reforms needed to achieve a modern, rights-based statutory child protection system. And on October 25, there was also a statement issued directly by ABSEC, which says, and again I'll only quote briefly, ABSEC, the New South Wales Aboriginal Child and Family Peak Organisation, is once again calling on the New South Wales Government to listen to Aboriginal people and communities instead of making blanket changes to child protection legislation that will adversely impact Aboriginal children, young people and families in New South Wales. And I seek also to table that document along with the other documents to which I have referred. In short, these changes have been dropped on the sector that deals with vulnerable communities, families and individuals without adequate consultation. Those who will be directly affected have not been given or afforded the opportunity to meaningfully engage with government about the terms of the legislation, its impact on their lives, and how perhaps terrible adverse consequences, no doubt unintentionally put into the bill, could be avoided. The real risks of inflicting further harm on vulnerable communities, particularly Aboriginal and Torres Strait Islander communities, has been raised by them. There is an alarm, a clarion call to pause and to actually reflect upon the terms of the legislation through an inquiry process. The government has not made a case in this legislation either for its reforms or for any urgency. There is no good reason, in our view, why the legislation needs to pass this week or indeed next, and why its passage could not await a proper inquiry so that the House, stakeholders and people who are to be subject to this new regime can have the opportunity to fully engage with government around these very significant changes. Now, I can foreshadow that to meet a number of concerns that I have outlined, the opposition has a mere 29 amendments that we will be discussing in committee. I understand that the Green political party has something like 24 amendments. I note the interjection from the Honourable Parliamentary Secretary to assist me. It's more than 24 amendments. I think what this really reveals, what this discloses, is very significant disquiet in this chamber, reflecting the even greater disquiet in the wider community, particularly by those who will be directly concerned. So to give honourable members a flavour of our amendments, which no doubt I will talk to in great detail in the committee stage, obviously the 2-year time limit is a real problem, and we'll be visiting that. Any time limit on restoration should be balanced with clear obligations on government and the Secretary of the Department to provide proper support to families and children facing removal, permanent removal. So we think, you know, it's all very well and good for government to lay down the law to people who are broken, people who are struggling, and more particularly to make permanent and far-reaching decisions for these vulnerable children without providing the resources or putting a reciprocal obligation on government to do its part more fully. If the government wants to raise the bar that vulnerable individuals and families have to meet, it should lift its own game. And I make it clear that my comments are not directed to the agency or its hard-working employees. I am talking about government policy. We're very concerned about the proposal to allow the court to make a guardianship order, even where there's no finding that a child is at risk of significant harm or should be subject to a care and protection order. We will address that as well. And we will also be making a variety of other changes, or proposing a variety of other changes in relation to the expanded regime being proposed by the government. We oppose any change to Section 90 of the Care Act, at least as it's currently configured. It's very difficult to bring an application or to vary or rescind care orders under Section 90, and the Children's Court is already empowered by Section 90 brackets 2 capital A little brackets little e to dismiss unmeritorious applications at the earliest stage. As I said earlier, Section 90 is already a high bar. There is strong opposition to any changes in the consultative process run by government last year. The additional limitations in the bill are unnecessary but also restrict the court's discretionary decision-making. And again, the government has not made the case for this change. We want to make sure that families are provided with legal advice and representation in any ADR process. We welcome ADR processes more generally prior to initiating court proceedings, but again, we are very concerned that families will not be able to participate in these processes on an equal footing to the department without access to independent legal advice and representation. So, Mr. Assistant President, hopefully the opposition's position has been made very clear on the Children and Young Persons Care and Protection Amendment Bill. We will not support it on the second reading vote, but we will move a range of amendments in committee, in the committee stage, to try and salvage the legislation. But what we will hope to do prior to the second reading vote is to persuade this House to press pause and to refer the legislation to the Social Issues Committee of this House to inquire into and report on the issues raised in the bill. And for completeness, let me say, we do not oppose the measures in the Cognate Bill dealing with working with children checks to be required of all those working in the National Disability Insurance Scheme system. With those comments, that is the...
mentioned in your speech certain documents you'd like to table. Just
Certainly, and I'm happy to show the Honourable Parliamentary Secretary. There's a statement by ABSEC dated 25 October. There's a joint sector statement made by various bodies, and there is a letter dated today to the Premier, again from 61 organisations and 700 individuals. I've read extracts from them, but I think for completeness I would like them to form part of the record of this debate if there's no objection. I do seek leave to table those documents as identified. I thank the Government and the Parliamentary Secretary for that indulgence. Thank you, Mr Assistant President.